Yo, right here. Right here in the small box. Right here in the small box. Welcome back to Single Seater Reactions only on the Flex Mind Network. I'm Flex. Welcome back to the channel. Why am I sneezing so much, bro? God damn. We're here with the Ville again, bro. We're here with the Ville. Salute to the Ville forever and always. Y'all know the vibe already. This video is titled UMG slams Drake with protective order regarding his discovery. Man, let's have some fun with this. Make sure you like, comment, share, subscribe, and the video. Drop a comment down below. Let me know what you think about the reaction. Hit that notification bell so you get notified when I drop my videos or when I'm live, like right now. Y'all see the timer. We get into it. Now, with that being said, let's go ahead and get started. Let's go. Let's see what's going on here. Talk to me.
What's going on, y'all? It looks like there's been an update in the UMG and Drake lawsuit. It looks like UMG
Australian T-Rex breakdancing lady is insane.
He is making sure that everything is straightened out before discovery goes all the way. Now, if
wait. UMG went back to back on Drake? That's the video title. Let's go.
You don't know, the discovery between UMG and Drake in this lawsuit was granted by the judge. The judge had confirmed that they're going to do this discovery. Now, a discovery is normal, just protocol. That is something that is normal in the court of law. It's a routine discovery. The discovery is a stage in a lawsuit where both sides exchange information and evidence relevant to the case, like documents, emails, depositions, and more. Drake wanted to see Kendrick's contracts. He had other requests about other information, emails, all this other stuff. And it looks like UMG decided to submit a protective order. That's right. UMG decided to submit a protective order, in particular to the discovery. Now, the reason why this is so important is for this reason alone. Everybody had asked, why does Drake want to see that information? He just wants to use that information in the discovery so that way he could diss Kendrick Lamar again. Well, this protective order will actually prevent all that from happening. You see, a protective order and a discovery go hand in hand. Like I said, a discovery is the stage in a lawsuit where both sides exchange information. Drake wants the contracts. People assumed he wants information so he could diss Kendrick Lamar again with information that he finds out.
I made that point too.
Through the court. However, a protective order and how it works with a discovery, if one party is concerned that sensitive information disclosed during discovery might be misused, an example, Drake leaking it to the public, used by competitors or might cause harm.
Yes! Oh, UMG's not letting this nigga win. UMG's not letting this nigga win because they know their artist. And we know this artist. We know this artist right here. He's going to do that. Whether if he's just going to leak it online or if he's going to mention it in a song. We know how he operates. He is so predictable. It's frightening. We know what he be doing for real. So, he is so cooked. Shout out to J Tom. Let's go, bro.
They can ask the court for a protective order. The protective order puts rules in place, like limiting who can see the information and how it can be stored or preventing it from being used outside the case. So even if Drake were to get information about Kendrick Lamar through UMG submitting a protective order could limit who can see the information, but not only that, how it could be placed and protected as well. Meaning that they could say that even if they grant Drake the discovery, this is to help prevent it from being used outside in this case. So they go hand in hand by enabling the discovery to move forward without risking harm from disclosure. And this is a common thing, actually. Courts often grant them to balance the need for full discovery with privacy or confidentiality concerns. It says it is hereby ordered that any person to this protective order, including without limitation the parties to this action, their representatives, agents, experts, and consultants, all third parties providing discovery in this action, and all other interested persons with actual or constructive notice of this protective order shall adhere to the following terms. Any person subject to the protective order who receives from any other person subject to this protective order any discovery material, an example, and information of any kind produced or disclosed pursuant to and in the course of the discovery in this action that is designated confidential pursuant to the terms of the protective order. Meaning, if you have access to this, you have to keep your mouth shut and not share.
But you know he won't. You know he won't. He's going to try and find a loophole to put the information out there. But it wouldn't matter because if you honestly think your split is better than Kendrick Lamar's split, I'm sorry, sir. Go to bed. Go to bed. It's time for you to sleep. It's time for you to get your pacifier, lie down in your crib, and fall asleep. Enough is enough. I want this to be over. I'm tired of this. I'm so tired of this. Is so embarrassing. And the fact that Torontonians are trying to back this, like he's really trying to do this for other artists. It is so embarrassing. It is so embarrassing to witness this. The embarrassment that I feel, and I'm not even an artist. It's so frightening. I was joking about it, but I wouldn't even be surprised they put tariffs on beats. Beats that are made outside of Canada, I won't be surprised if the producers start putting tariffs on the beats. What is Canada gonna do then? It's damn near like y'all exiled. Y'all gotta spend y'all pocket for a beat now. Imagine that. Can he get his money at least? Facts. I know it's technically not what they are doing as such, but when they argue the way they do, it does feel like UMG is going full zesty pitbull protection mode for Kendrick. I won't even say it's for Kendrick. It's for themselves. To be honest. They're in full protection mode for themselves. It's a mutual protective order, so it protects both sides. Drake's stuff will be protected as well. Regardless, but PB, they don't need Kendrick shit either. Or they don't need Drake shit either. They don't need it. There's no business needing that shit. It doesn't do anything. We know about your splits because we can go and seek that information. We don't need to confirm it. It's not necessary. We've heard it from Birdman himself. We've heard it from Birdman himself with that reaction I did. I'm sorry that the reaction was 2 hours, but trust me, we've heard it from him when he sat down with Nick Cannon. Jay Nolan covered it. I did a reaction to it. But we covered these things. We don't need the official paperwork to figure it out. Even ABSA figured it out. It's not that hard to look up these things at all. As long as you have the right source, you can make it happen. You don't need Kendrick's papers, because Kendrick's good.
Or leak it. You shall not disclose such confidential discovery material to anyone else.
That's a good point too, Rebecca. They own him, so they're supposed to know his business.
Except as expressly permitted hereunder. 2, the person producing any discovery material may designate confidential only such portion of such material, the public disclosure of which is either restricted by law or would cause harm to the business, commercial, financial, or personal interests of the producing person and or a third party to whom duty of confidentiality is owed, and that consists of previously non-disclosed financial information, including without limitation profitability, reports of estimate percentage fees, design fees, royalty rates, minimum guarantee payments, sell reports, and sell margins. Basically the numbers, the sales, contracts, all that. You can't share that. You can't share that to the public at all. So even if Drake has access to the numbers, it's not like he could go out there and share them. And if he does, he might face legal repercussions in doing so.
Facts.
Previously non-disclosed material relating to ownership or control of any non-public company, previously non-disclosed business plans, product development information or marketing plans, any information of a personal or intimate nature regarding any individual, which in this case...
There you go with Jay Thompson. They own his masters, bro. They own that shit. You know what I'm saying? Drake is cooked in this shit. So his lawyer, the best choice for their lawyer right now is to dead this. End it. I think they argue like that specifically because they definitely get support from K-Bar. Don't kill me.
Could be Kendrick Lamar or any other category of information here and after given confidential status by the court. Now, this third paragraph is interesting only because they talk about the deposition. They talk about the deposition and how that could be protected under the protective order as confidential information. Depositions are handled a little bit differently in a protective order. And I think them pointing this out could be the reason why Kendrick is also doing the deposition at his concerts. I'm not sure if he's aware that he might actually do a deposition But from what it looks like this protective order could protect any confidential information that's shared in a deposition. It says here, bottom line, depositions can absolutely be protected, but they usually follow their own procedure. They're not automatically public, nor are they automatic.
So when he tried to pocket watch Kendrick, there was a counterplay to protect discovery. Boy. Just like that. I wonder if Drake ever had to have UMG pay someone off for him. Hell yeah.
Automatically protected forever. Someone has to designate them properly. During the deposition, a party or their lawyer can designate certain testimony as confidential on the record, or more commonly, the transcript is treated as confidential in its entirety temporarily. For example, it could remain confidential for 30 days, giving parties time to review and decide what parties, if any, to mark confidential. After that review period, only the designated parts remain protected. So they'll hold the whole deposition back for whatever time they can, just until they could give it back to the public and redact anything else that they want to keep confidential. But I'm not sure if that's the real reason why Kendrick was doing this deposition scene at his concert on tour. I don't know if he knows he's going to do a deposition, but I just think it's funny how he's doing this cut scene of a deposition on tour. Either way it goes, it looks like the deposition could be protected under this protective order after they exchange discoveries. And 4 and 5 explain that. 5 is also explaining that how a discovery material previously produced by the producing person without limitation could be designated confidential. Then the producing person may so designate by so apprising all prior recipients of the discovery material in writing, and thereafter such designated portions of the discovery material will be deemed to be as treated as confidential under the terms of the protective order. So 4 and 5 basically break down that if there's stuff that needs to be taken out or remain confidential, the protective order will protect that. 6 says, nothing contained in this order will be constructed as a waiver by party or person of its right to object to any discovery request, a waiver of any privilege or portion, or a ruling regarding the admissibility at trial or any document, testimony, or other evidence. Whether producing a person has designated discovery material confidential, other persons subject to this protective order may only disclose such discovery material or information contained therein too. The parties to this action, their insurers, a counsel to their insurers. Counsel retained specifically for the action, including any paralegal, clerical, and other assistant employed by such counsel and assigned to this matter. Outside vendors or service providers such as copy service providers and document management consultants, graphic production services, or any other litigation support services hired by counsel and assigned to this matter, including computer service personnel performing duties relating to computerized litigation system, provided such person has first executed a non-disclosure agreement, also known as an NDA, in the form attached hetero. Any mediator or arbitrator engaged in the parties in this matter or appointed by the court, provided such person has first executed an NDA in the form attached hereto, as to any document, its author, addressee, and any other person indicated on the face of the document as having received a copy. Any witness who, in the good faith belief of counsel for a party, may be called to testify at trial or deposition in this action, provided such person has first executed a NDA in the form attached hereto. Any person retained by the party to serve as an expert witness or otherwise provide specialized advice to counsel in connection with this action, provide such person as first executed on NDA in the form attached hereto. Stenographers engaged to transcribe deposition conduct in action and the court, including an appellate court, and the court reporters and support personnel for the same. All of this to basically say that anybody that's partaking in this case dealing with the material inside the protective order must sign an NDA, so that way they don't go and expose the information that they were exposed to that is deemed confidential. Only certain people are typically required to sign NDAs before accessing confidential materials.
Yes, sir, Devin, bro. But this is going to be the last one I do in a while, man. This is going to be the last one I do in a while. But, yo, just watching this, man. Just watching this is just all kinds of hilarious. This is all kinds of hilarious here.
Site vendors or service providers, copy services, IT, litigation support, graphic designers, basically making sure that nobody goes and blabs to anybody about the information that they saw in this case. If an attorney brings somebody in, like a technical expert or a financial consultant, they usually must sign the NDA before viewing confidential material. This is just going all over that. Any party who's subject to a designation of confidentiality may at any time prior to the trial of this action serve upon counsel for the designating person a written notice stating with particularity the grounds of the objection. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with the Rule 6 of this court's individual rules and practices in civil cases. Any party who...
Bro, Rebecca, it's not even all kinds of stupid anymore. This is just one great big waste of time. This is one great big waste of time. This should never have happened. This should never have happened. There is no way on God's given earth where something like this would actually, you would actually win from this. There's no way. There's no way. I'm ready for some music when you are, Flex. I'm feeling for some request opportunities, and I have dollars burning a hole in my pocket. Damn, Tammy. We can do some music soon. Damn.
Request additional limits to disclosure, such as attorney's eyes only in extraordinary circumstances, may at any time prior to the trial of this action serve upon counsel for receiving party a written notice stating with particularity the grounds for the request. If the parties cannot reach agreement promptly, counsel for all parties shall address their dispute to the court in accordance with Rule 6 of the court's individual rules and practices in civil cases. Notwithstanding, the foregoing parties agree that any party may designate as attorney's eyes only and previously non-disclosed contracts, agreement, contractual terms, clauses, or provisions, and any document containing excerpts of substantive discussions about the same, the disclosure of which would be highly likely to cause significant harm to the business or competitive position of the producing party. The parties further agree that the defendant may designate as attorney's eyes only any document identifying confidential or proprietary business information regarding defendant relationships with other recording artists or non-parties to this litigation, including but not limited to confidential financial or payment information, revenue reports, royalty rates, licensing rates, and any other commercially sensitive documents. This disclosure, the disclosure of which would be highly likely to cause significant harm to defendant's business or competitive position. The parties further agree that plaintiff may designate as attorney's eyes only any documents identifying confidential or proprietary business information regarding plaintiff's business relationship with non-parties to this litigation, disclosure of which would be highly likely to cause significant harm to the plaintiff's business or competitive position. Any materials designated attorney's eyes only under the paragraph 10 may only be shown to the people in paragraph 7. This part is very interesting for the reason why is the attorney eyes only. Now, the bottom line for attorney eyes only, the materials are very restricted to protect business critical information. There's a process to request it, but some categories are already agreed upon as qualifying. Parties themselves, like plaintiffs or defendant, usually can't see attorney eyes only materials. Only their lawyers and the experts can. So Drake himself, he can't see the information. If certain documents are designated for attorney's eyes only, Drake himself likely cannot even...
Bro, I keep saying, like, yo, what more can I... What more can I say? Because I know how reactors are. Like, I'm going to start becoming repetitive if I was just going to sit here and continue to say the same thing over and over. That's why I'm not talking. I'm getting so repetitive. Like, this is literally the biggest waste of time. I don't need to break it down further. I don't need to do that. I'm literally sitting here hearing how embarrassing this is for Drake. This is so embarrassing, bro. Of course Drake is going to try and see it. Oh, fun fact. There used to be a strip club in Toronto called For Your Eyes Only, just an FYI. That's also a little tidbit for all the rabbit hole individuals out there. Do what you want with that. But what more do I need to say? Like, I'm sitting here, I'm laughing internally. I'm nodding my head, agreeing and understanding what's going on. I've been saying this is just stupid. Like, you're not winning. You really sit here and think that you're really gonna use, you thought that you were gonna use these papers, all these documents, And you thought you were going to leak that on the internet, not realizing how the court system works. You're going to get serious repercussions if you ever think about doing that, or ever think about showing other people, especially stupid top 5, because you know how he likes to run his mouth. All he does is run his mouth. That's it. Like, it's just gotten to a point where it's like, yo, like, this is just so dumb.
Even see them, even if he wanted to. AEO, or attorney eyes only designation, is specifically meant to exclude the parties themselves from viewing extremely sensitive information, even their own lawyer's client. The idea is to prevent business or competitive harm if that information were to be shared with someone who could use it, even unintentionally, to their advantage. In this case, with Drake and UMG, Drake's lawyers can review and use the attorney eyes only material to defend him, but Drake personally can't see it. Let's say a music label produces confidential royalty rates from another artist's contract, and UMG labels them attorney eyes only. Even though that info may relate to industry practices that Drake cares about, he can't see it. Only his legal team can. If they're involving highly sensitive information, they're making sure they set everything straight before giving it to Drake's team, just to make sure that only his legal team could look at it, and to be very sure that Drake doesn't leak this information out to the public, bro. A lot of people thought that that's what Drake wanted to do. Drake wanted to get Kendrick's contract.
Literally me included. I thought he wanted to look at the contracts to leak it out on the internet so people can supposedly laugh at him because they don't even understand what they're reading.
He wanted to leak it. He wanted to share. He wanted to share whatever it is that he saw. But it looks like they're doing all the proper procedures to make sure that that doesn't happen. A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party. Within 5 business days of receiving the request, the receiving party subject to such obligations shall inform the third party of the request, and further that the third party may seek a protective order or other relief from this court. If neither the third party nor the receiving party seek a protective order or other relief from the court within 21 days of that notice, the receiving party shall produce the information responsive to the discovery request, but may affix the appropriate confidentiality designation. So 12 and 13 is basically letting you know that even though that this might be a protective order, and even though it keeps information confidential, this doesn't prevent anybody from having a fair trial, a fair case, a fair day in court, however you want to put it. 13 is saying if anybody decides to get involved, any law or government agency, which is interesting, decides to get involved in this case, they would have to notify the court, I'm assuming is what they're saying here. In accordance with Section 10 of this court's individual rules and practices in civil cases, the party filing documents under seal must first file the court a letter motion explaining the basis of the sealing such documents. The party should be aware that the court will unseal documents if it's unable to make a specific on the record findings, demonstrating that the closure is essential to preserve higher values and narrowly tailored to serve that interest. There is no presumption that confidential discovery material will be filed with the court under seal. The parties will use their best efforts to minimize such sealing. The court also retains unfettered discretion whether to afford confidential treatment to any discovery material designated as confidential and submitted to the court in connection with any motion, application, or proceeding that may result in an order and or decision by the court. All persons and hereby place on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial. Even such material was previously sealed or designated confidential. This right here is letting you know that at the end of the day, the court is what deems what is confidential and what is not. Now, that's what 15 is basically telling you right here. Filing confidential discovery material with this court or filing portions of any pleading motions or the papers that disclose such confidential discovery material, the party shall publicly file a redacted copy of the confidential court submission via electronic case filing system. The party shall simultaneously file under seal via ECF with the appropriate level restriction and unredacted copy of
I ain't gonna lie, I don't know how these lawyers do it, bro. God damn.
Confidential court submission with the proposed redactions highlighted. Each person has access to discovery material that has been designated confidential, shall take all due precautions to prevent the unauthorized or inadvertent disclosure of such material. Number 18, they talk about personal information such as names, numbers, and all that, socials, all that. If a disclosing party makes a claim of an inadvertent disclosure, the receiving party shall, within 5 business days, return or destroy all copies of the inadvertently disclosed information and provide a certification of counsel that all such information has been returned or destroyed, making sure that the material is not kept.
So it's literally what I'm getting at is just a whole bunch of like reassuring and confirmation that no, you're not touching this. There's some things you can't touch. You shouldn't even be here. You can look at this document, but that's it. But at the same time, it's like, oh, you can't even look at that either. Like, that's literally what I'm getting at right now, because at this point, I'm just like, bro, it's just a bunch of extra words put together to let you know you're not touching this.
Sure that they do get rid of it if they have to get rid of it, whatever the case may be. Within 5 business days of the certification that such inadvertently disclosed information has been returned or destroyed, the disclosing party shall produce the privilege log with respect to an inadvertently disclosed information. Got to confirm that. Got to make sure that they do not keep information. Got to make sure that they delete it, remove it, burn it, whatever they got to do. The court has to make sure that they haven't kept anything after the fact. The receiving party may move to the court for an order compelling production of the inadvertently disclosed information. The motion shall be filed under the seal and shall not assert as a ground of entering such an order fact circumstances of inadvertent production. The disclosing party retains the burden of establishing the privileged protected nature of the inadvertently disclosed information. Nothing in this order shall limit the right of any party to request an in-camera review of an inadvertently disclosed information. The protective order shall survive the termination of the litigation and will continue to be binding upon all persons to whom confidential discovery material is produced for. Within 30 days of the final deposition of this action, all discovery material designated confidential and all copies thereof shall promptly be returned to the producing person. Alternatively, upon permission of the producing person of all confidential discovery material, all copies thereof shall be destroyed. In either event of a 30-day deadline, the recipient must certify that the return or the destruction of confidential discovery material and all copies thereof by submitting a written certification to the producing party that affirms that the recipient has not retained any copies, compilations, summaries, or other forms of reproducing and capturing of any confidential discovery material. Notwithstanding the provision, the attorney specifically retained by the parties for representation in this action may retain an archival copy of all pleadings, motion papers, transcripts, export reports, legal memoranda, correspondence, or attorney work product, even if such materials contain confidential discovery material, and such archival copies that contain the constitute confidential discovery material remain subject to this order. All persons subject to protective order acknowledge that the willful violation of the protective order could subject them to punishment for contempt of court. This court shall retain jurisdiction over all persons subject to the protective order to the extent necessary to enforce any obligations arising hereunder or to impose sanctions for any contempt thereof. Basically, if Drake goes around and violates anything regarding this protective order, he could face legal repercussions and he could see himself go to court because of it. This is big dog business. I really do believe that they're letting Drake know that you're not going to leak any information that you get from us. Actually, you might not even see any of the legal information that we give you. The only people that have a right to see that information is Drake's lawyers themselves. Attorney eyes only. Either way, this protective order is something that they're going to make sure that they do. So that way Drake doesn't go and leak information, isn't going to go online, isn't going to make a song or a diss track talking about Kendrick Lamar's contract. You're not going to see any of that. Why? Because if he does that, then he breaks the protective order and he has to see a day in court and face legal repercussions for that. But like I said, I didn't pass the bar exam. This was just a good read, a little late update in regards to the UMG and Drake lawsuit. Y'all tell me how you feel about this in the comments and get back to me, man. Now. But UMG said that the discovery goes both ways, and be careful what you wish for because you just might get it. But y'all tell me how you feel about this and get back to me, man. Like, comment, subscribe, and I'll see y'all in the next video, man. Peace. Keep it a legend.
Gotta make sure you keep that hand on that Bible now. Make sure to keep that hand on that Bible before you even go ahead and do nothing now. Like I said, what more do I need to say? What more do I need to say? Bro, this should be over. If they are still trying after this, I don't even know where to begin. How to just feel this embarrassment. I don't know which avenue to step in to just feel embarrassed. Because, like, you're wasting your time. You're wasting the money that you technically don't have. It's just not a good look. If you continue to do this, like I said before, I won't be surprised if they put tariffs on the beats. I won't be surprised if they put tariffs on the production for anything that happens outside of Canada in terms of producing. I won't be surprised. You want your beats homegrown? Okay. This will go happen now. This is crazy. I won't be surprised. And the funny thing is, you don't even need to look to the United States to say, oh, yeah, can you put a tariff on this? No, you can do it yourself. 30%. Come on, let's go. 30%, 50% extra. That's right. 50% premium on top of the original price. You got it? Imagine if you want a beat from Dreamville. The amount of millions you got to pay. It may, and I can tell you that this summer is about to be brutal out here. Facts. Facts. And another thing that I want to mention too, that a lot of the record labels have been making some silent changes with how they with how they deal with artists and do business with artists. They've been making some silent changes over the times. Ever since this whole lawsuit started, they've been making silent changes. A lot of people are thinking, oh, Drake is making them make these changes. I don't think people are reading this well enough. It's social media, so it's fair. Watch this. Watch this. All those changes that they are making within the music industry, within the business, that's the shift. They understand there's a shift. Remember what I said about numbers and how numbers can tell a story. Numbers are also used to predict the future as well. Sorry, not sorry. If there is a constant repetition in terms of how the charts flow, regardless if it's up, down, however, if it's the same or similar moment that's happening over and over every couple of months, every couple of years in terms of charting, understanding the charts, understanding the numbers, you can use that to see what's going to happen later on. It's not going to be perfect, but you can use it as an example. And by using that as an example, you can start to make changes in your policies. A lot of artists may be cooked before they even realize it. I'm curious about what era of music this is going to emulate. The changes that they're making, I'm trying to figure out what era of music are they trying to emulate, because one thing about history is that history likes to repeat itself. And I'm wondering, which era are we going to recreate in today's world? A lot of people are saying that, oh, by Drake doing this, he's helping other artists. No, it's making it worse for other artists. A lot of artists that are currently in the game are going to start to fall out. And artists that can manage the new changes are the new people that are going to step in. That's what's happening. 94 degrees Fahrenheit yesterday in the 70. Oh my God. But yeah, like, that's what I believe. Of course, it's my own opinion. Since you come to my channel for my opinion, I might as well give y'all something. But that's what I think that's going on. A lot of these changes might be detrimental for current artists. That's why a lot of people can't be dropping like how they used to anymore. If y'all noticed that. I know y'all did. A lot of people ain't dropping like how they used to. There's been some changes going on. I want to see if I can go back and find those little, like, posts, those little articles that I read. I want to see if I can find it, not today, or tomorrow, but when I find it, I want to see if I can bring it here and just, like, read that for y'all. You know? But at the end of the day, this is still one great big waste of time, and we're still here for some reason. Sad, it's disappointing, and there's nothing we can do. So let's go ahead and keep going with this.